The Senate will come to order. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Creighton, Eckhart, Flores, Gutierrez, Hall, Hancock, Hinojosa, Huffman, Hughes, Johnson, King, Colhorst, La Mantilla, Menendez, Middleton, Miles, Nichols, Parker, Paxton, Perry, Schwertner, Sparks, Springer, West, Whitmire, and Zaffarini.
Members, there being a quorum present, please rise in the gallery and on the floor for the invocation delivered by Pastor Doug Weckerman, Red Rocks Church in Austin. Pastor, welcome.
Good morning. Thank you for having me. I'm honored to be here. Let's pray. Wonderful God, thank you for reminding us in Romans that you are the one who has established the existing authorities. Let that give us confidence in our callings today. Remind us that your ways are higher and your thoughts are greater, and let that give us humility. Thank you for the men and women gathered in this space. Thank you for the grit, passion, and courage you've given them to lead. Give each and every one of them a humble confidence in the gifts you've given them and your good intentions towards them. Thank you for allowing us to partner with you in bringing the world forward. I pray this in your beautiful and powerful name. Amen.
Thank you, Pastor. Dean of the Senate moves to dispense with the reading of yesterday's journal. Any objection? Hearing none. Motion is adopted. Chair announces the signing of the following of the Presidents of the Senate.
Senate Concurrent Resolution number 19.
I want to welcome those of you in the gallery, to your capital during spring break. Good to have you visiting with us. You're saying where are all the senators? Some committee meetings are meeting late, so they finish up their meetings and come on the floor, if you're wondering. Following message from the governor, secretary will read the message.
To the Senate of the 88th Legislature, regular session, I ask the advice, consent, and confirmation of the Senate with respect to the following appointments. To be a member of the Texas Department of Housing and Community Affairs, Holland R. Harper, Paris. To be members of the Texas Board of Physical Therapy Examiners, Manuel A. Tony Dominich, Austin, Donovan J. Hodge, Spicewood, Omar Paloman, McAllen. Respectfully submitted, Greg Abbott, Governor of Texas, to nominations.
Following motion in writing.
Motion in writing. Mr. President, I move that the nomination of Todd Boykin to the Red River Authority of Texas Board of Directors be withdrawn from the Committee on Nominations, and I further move that the nomination be returned to the governor pursuant to his request. Motion by Senator Campbell.
Any objection to the motion? Hearing none. Motion is adopted. Senator Nichols for an introduction.
Thank you, Mr. President and members. It is my honor and privilege to recognize and welcome the residents of Palestine, the county seat of Anderson County. I ask all y'all to stand up. Palestine is the home of the annual Dogwood Festival. It began in 1936 with a driving tour of Davie Dogwood Park. Historic Texas State Railroad also travels through Palestine and the scenic piney woods of East Texas. The area hosts sites on the National Register of Historic Places, including one of the only 12 remaining Carnegie Library buildings in the state. Please help me welcome the delegation from Palestine. Thank you.
Thank you, Senator Nichols. Members, if you want to take your seats for a moment, we have a special guest joining us today. If you all would like to take your seats, we have a special guest on with us today. Chair lays out the following resolution.
Oh, they don't know.
Nope, not that one. Not that one. Secretary will read the resolution by Paxton.
Senate Resolution 301 by Paxton et al., honoring Dennis Quaid for his many achievements.
Senator Paxton, you're recognized.
Thank you, Mr. President. And members, it is my honor this morning to recognize native Texan and accomplished actor Dennis Quaid. Mr. Quaid was born in Houston and graduated from Bel Air High School, then went on to attend the University of Houston. I also, as I told you, went to the University of Houston for my master's, and that is the end of our similarities, I guess. He left college to move to Los Angeles, and he quickly landed roles in a number of productions. His on-screen breakthrough came in 1979 in the coming-of-age drama, Breaking Away. Mr. Quaid most notably appeared in The Right Stuff as Houston astronaut Gordon Cooper, and in 1984 he appeared on stage in Sam Shepard's True West. He later demonstrated his range as an actor, playing a Louisiana detective in The Big Easy, U.S. Navy aviator in the science fiction comedy Interspace, and rockabilly legend Jerry Lee Lewis in the biopic Great Balls of Fire. Beginning with The Parent Trap in 1989, Mr. Quaid enjoyed one of the most successful stretches in his career, earning plaudits as a beleaguered quarterback in Any Given Sunday, as an unsavory lawyer in Traffic, and as a middle-aged high school baseball coach who tries out for the big league in The Rookie. In 2003, he received an Independent Spirit Award for his powerful performance in Todd Haynes' family drama, Far From Heaven. And 2 years later, he portrayed Lone Star State legend, none other than Sam Houston, in a remake of The Alamo. Along the way, he acted in hit films such as The Day After Tomorrow and In Good Company. And in 2010, he received Emmy, Golden Globe, and Screen Actors Guild nominations for his depiction of former President Bill Clinton in The Special Relationship. Over the next decade, his credits included starring in the CBS series Vegas, and more recently, he served as a narrator in David Tice's documentary Grid Down, Power Up, which focuses on the potential dangers of the U.S. power grid going down. And in addition, is one of the reasons that you are here today in Austin. Members, Mr. Quaid was inducted into the Texas Film Hall of Fame in Austin in 2005. And in addition to his work as an actor, Mr. Quaid is a talented musician. And he and his band, The Sharks, released their debut album, Out of the Box, in November of 2018. For more than 4 decades, Dennis Quaid has delighted audiences on stage and screen in a wide range of dramatic and comedic roles, and it is indeed fitting to acknowledge the contribution of this very, very talented Texan. So members, I know that you join me in welcoming to the Senate floor Dennis Quaid.
Senator Hall, you're recognized for a comment.
Thank you, Mr. President. Yes, thank you, Senator Paxton, for bringing this. And you read off a rather long list of very, very successful performances that Dennis Quaid has had in his career, starting with being a Texan. But all of those, and I think I saw every one of them, he will remain with me for his performance as the narrator for the movie that David Tice produced of Grid Down, Power Up. And mainly it's because of the way that he delivered the message in that, because it was obvious it was coming from his heart, not from a script, that he understands the threat we have to our grid, and he wanted to do his part in making sure that everybody understood it in a way that they could understand what the problem really is. And so it's a real honor to have him here today. In light of his career, what he did, for him to step in and be a part of this is just fantastic. And I want to thank you, and thank you for the rest of Texans who have seen it. And if you haven't seen it yet, you owe it to yourself to watch it at least twice. Okay, thank you.
Thank you, Senator Hall. And we're going to try and do a screening, members. arrange it for all of you so you can view it. We've had a great chat about it. He's concerned about the grid and its security, as we all are. And so thank you, Dennis, for participating in that. And since he won awards for Clinton, he's now playing Ronald Reagan in a new movie that's coming out this year. So that's an actor when you can do Clinton and Reagan. So
Balanced.
members, the motion is on the adoption of the resolution honoring Dennis Quaid. Oh, Senator Betancourt, your light's on? I did not see it.
Thank you, Mr.
You're
President.
recognized.
I just want to remark, Dennis, if you can play Bill Clinton, Ronald Reagan, and Sam Houston, you're welcome not only in the capital of the Texas, but probably in every capital in this country. You're a national treasure. Thank you.
Thank you, Senator. The adoption of the resolution, any objection? Hearing none. Resolution is adopted. Thank you for being with us, Dennis. Thank you. Member Senator Cole, of course, has moved to add all names to the resolution. Any objection? Hearing none.
Chair lays out the following resolution. The Secretary will read the resolution.
Senate Resolution 304 by Hancock and Miles, recognizing March 9th, 2023 as World Kidney Day and commending the Chronic Kidney Disease Task Force.
Chair recognizes Senator Hancock on the resolution.
Yes, thank you, Mr. President. Today I do rise in honor of the hard work and dedication of the members of the Chronic Kidney Disease Task Force and to recognize the passing of World Kidney Day on March 9th. Members, there are more than 8,000 Texans today waiting on a kidney transplant. I do praise God that He saw fit to bless me with one. In fact, we did a little sonogram of it yesterday with a living donor, but many continue to wait for their match. In fact, over 70,000 Texans are currently on dialysis today. The work of the Chronic Kidney Disease Task Force to study and develop statewide plan to address the debilitating and frankly infuriating disease is so critical for Texans living with chronic kidney disease. The World Kidney Day encouraged us to increase awareness of the importance of our kidney functions, and I think I can attest to how important that healthy kidney is. So in honor of World Kidney Day, please join me in thanking the members of the Chronic Kidney Disease Task Force that are here with us today. If y'all would stand up. And Senator Miles has a few things to say as well. He is right below you. Trust me.
The Chair recognizes Senator Miles on the resolution.
Thank you, Mr. President. Thank you, Senator Hancock. And I am right below you. I know you can't see me. Members, it's a great honor that I joined Senator Hancock to welcome members of the Chronic Kidney Disease Task Force to celebrate World Kidney Day. Members, as many of you know, Senator Hancock and I are 2 of 37 million people in this country who have had kidney diseases. Those who have been diagnosed with this illness know the pain and symptoms associated with living with this disease. It's not easy. The pain we go through not only affects us physically, but it also affects and impacts our families. Senator Hancock and I were blessed to receive kidney transplants, but many people are not so lucky. I want to thank the members of the Chronic Disease Task Force and joining us today in the gallery. Thank you for the work that you've done and you do to support preventative diagnosis, treatment of managed care and chronic disease in Texas. And Ms. Littlefield, I'm also honored to co-author along with my colleague, Senate Bill 1354 to establish the Rita Littlefield Chronic Kidney Disease Centralized Resource Center to provide ready, accessible information about this disease to the public. Together, I know that we can save lives and ensure that all Texans with kidney disease or those at risk receive quality care and have access to information about preventing and managed care of this disease. Members, thank you for allowing us to share our stories and helping us celebrate World Kidney Day.
Chair recognizes Senator Betancourt on the resolution.
Thank you, Mr. President, members, and for the gallery here, and because the members well know this, we wouldn't have 2 members here today if it hadn't been for these kidney transplants. Brother Miles and Brother Hancock. And that's how important this is. So when you look at a Texas Senate, you need to understand that we know that when we can save a life, it's probably the best day we have in this body is to save the lives of everyday Texans. And I'm looking at 2 that wouldn't be here without a kidney transplant. So understand that we're always with the side of life, because that's what you see here today. But what a kidney transplant gives people is an extra life. So I want to commend both Senator Miles and Senator Hancock for bringing this resolution. And I just wish there was National Pituitary Day, because I survived that one. But we'll get to that some other day. So why don't you give these great senators a hand and the Kidney Foundation a hand for their tremendous work and their saving lives of everyday Texans. Let's hear it. Spread all the names on, if we could, Mr. President, put all the names on the resolution of the members. Thank you.
Senator Betancourt moves to add all names to the resolution. Is there no objection? Chair hearing none, is adopted. Is there objection to the adoption of the resolution? Chair hears none. The resolution is adopted. Chair lays out the following resolution. The Secretary will read the resolution.
Senate Resolution 299 by Hall, commemorating the 20th anniversary of the #1 British Flying Training School Museum at its current location.
Chair recognizes Senator Hall on the resolution.
Thank you, Mr. President. Mr. President, colleagues, and guests, it is my honor to stand before you today to recognize the 20th anniversary of the #1 British Flying Training School Museum in Terrell, Texas. And we have a couple of the folks with us today. Would Bill Huthmacher and Patrick Hoddard stand up, please? Thank you, guys. All right. The museum holds a special place in our hearts as it preserves the legacy of the brave pilots who trained here during World War II. Between 1941 and September of 1945, 25 courses completed their training at the school, with cadets moving into the Terrell facility in August of 1941. It is remarkable to think that this local citizens contributed $35,000 towards the purchase of the land needed to construct the airfield. Private funding allowed for the rapid purchase of the real estate, which sped up the construction of the facility. It's also important to note that over 2,200 British and American personnel trained at #1 BFTS during the war, with over 1,400 graduating. These men were the backbone of the British Royal Air Force and the American Flying Forces. The sacrifices they made for their countries will never be forgotten. Sadly, 20 BFTS cadets are buried in Terrell's Oakland Memorial Cemetery, having passed away while training. Their service and ultimate sacrifice will always be remembered and honored, and it's also important to recognize that the 6 BFTS schools graduated a total of 6,602 pilots for the Royal Air Force and 551 pilots for the American Air Force. The numbers themselves may seem small, but their impact on the outcome of the war was immense. The museum preserves a collection of relevant items, including logbooks, training materials, uniforms, aircraft models, equipment, photos, memorabilia. The museum's patrons continue to learn about the flying training and its contributions to the Allied victory through tours, educational programs, and off-site lectures delivered by the board and staff. The museum remains dedicated to the mission of educating the public about the British Flight Training School, its role in World War II, and the history of the Anglo-American Cooperation. I would like to congratulate the #1 BFTS Museum on its 20th anniversary and recognize Bill Huthmacher and his board chairman and Patrick Hoddard, the executive director. Their efforts in preserving the legacy of these brave pilots will ensure that future generations never forget the sacrifices they made. I'm very proud to represent them in Texas Senate. Please help us welcome and congratulate the #1 British Flying Training Museum for their great accomplishments.
Is there objection to the adoption of the resolution? The chair hears none. The resolution is adopted. Members, if you will please take your seats for a memorial resolution. Members, we have a memorial resolution. The chair lays out the following resolution. The secretary will read the resolution.
Senate Resolution 300 by King and Springer. Whereas a rich and purposeful life drew to a close with the passing of James Doyce Flanagan of Weatherford on November 24, 2022, at the age of 65. And whereas the only child of Paul and Octavia Flanagan, Jay Flanagan was born in Fort Worth on January 25, 1957. He graduated from Weatherford High School and continued his education at Weatherford College and the University of Texas at Arlington. And whereas through the years, Mr. Flanagan worked in the oil and gas sector and in the flooring industry, and he also built houses. Ultimately, he concluded his career as a parts manager for a passenger rail company. And whereas in all of his endeavors, Mr. Flanagan enjoyed the love and support of his wife, the former Judy Langford, with whom he shared a rewarding marriage spanning nearly 4.5 decades. He was the proud father of a son, Bill, and he experienced the joy of welcoming 2 grandchildren into his treasured family. And whereas Mr. Flanagan was a longtime member of Greenwood Baptist Church, he was ordained as a deacon in 1984, and he was actively involved with the church baptistry, the men's ministry, and the Exceptional Rodeo, an annual event that was established for youth with special needs. Moreover, he led Bible studies for people of all ages, most recently teaching a 4th and 5th grade group with his wife. The couple also served together as Mission Service Corps volunteers from the 1991 through 1993. A Gideon, Mr. Flanagan spent several years distributing Gideon New Testaments to students at local school campuses. He was known for his hospitality and compassion for others, and he loved spending his leisure time on the water, pursuing his passion for fishing. And whereas although Jay Flanagan is deeply missed, memories of his devotion to his family and his faith remain to comfort and inspire those he leaves behind. Now therefore be it resolved that the Senate of the 88th Texas Legislature hereby pay tribute to the memory of James Doyce Flanagan and extend heartfelt condolences to the members of his family, to his wife, Judy Langford Flanagan, to his son, Bill Lynch, and his wife, Michelle, to his grandsons, Dawson and Trip Lynch, and to his other relatives and friends, and be it further resolved that an official copy of this resolution be prepared for his family, and that when the Texas Senate adjourns this day, it do so in memory of Jay Flanagan.
Chair recognizes Senator King on the resolution.
Judy, come stand by. Thank you. Members, I'll try to get through this one, Mr. President. You know how with our staff, they just don't become staff. They become part of your family. And Judy and I have worked together for 30 years. She was a long time district director for me in the House seat until she retired last year to take care of her husband, Jay. And we all know how it is. You just don't get to be family with your co-workers in the Senate, but you get to be family with their family. And Jay was somebody that really became a family, but he wasn't just a family to Judy and their family in the gallery. He wasn't just a family to me. He was a family to everyone who ever met him. I went to his funeral service, and you've probably been to a couple of services like this. There aren't very many. But it's where when you leave, you're thinking, that's the kind of person I want to be remembered as. I want people to say those type of things about me at my memorial. And it was that way with Jay. Aside from being just a great, down-to-earth, fun, country guy. But we had at their church, Greenwood Baptist Church, it was a huge audience. And at one time, the pastor said, would you please stand up if over your years of knowing Jay, he has mentored you, discipled you, counseled you, made a really significant impact in your life? And I kid you not, almost everybody in the building stood up. And that's just the kind of guy he was. I'll say is because I know he's in heaven with his Lord and Savior right now. But Judy, we just wanted today, we all love the people that we work with in the Senate and in the House. And my family loves your family, and we loved Jay. And if I could just introduce some folks that are with her today. We have her son, Bill Lynch, and Michelle. Would you please stand up? Just so everybody can see who you are. Their grandkids, Dawson and Tripp, and then Judy's sister-in-law, Marnita Stennett. And we just want you to know that we just extend our love to y'all as well. I thank you for loaning Judy to us all these years to serve the legislature. She's made such an impact in so many people's lives in the district. And Judy, I know you'll see Jay again hopefully it's a while, but we never know. But I know you'll see Jay again. And I just want to tell you what an honor it was for me to get to know him. And we just want to honor him today with this resolution. So with that, Mr. President, I would move adoption.
Would all those in favor of the resolution please rise? The resolution is adopted. Chair recognizes Senator Campbell for an introduction.
Thank you, Mr. President. Members, I'm extremely proud and grateful to recognize the Garden Ridge Lions Club, which is celebrating its 50th anniversary of serving Southern Comal County and New Braunfels. Please stand up. For the past 5 decades, the Garden Lion Ridge Lions have served their community in areas that they're needed most. They facilitate programs that directly change people's lives, including delivering food and gifts to families during the holidays, offering hearing and vision evaluations for students in our public schools, building ramps for those experiencing mobility issues, and providing refurbished eyeglasses to people in developing countries. And let me tell you, when I was in Ghana, Accra, Ghana, doing eye surgeries, the glasses that we used came from our Lions Club. So when I say they are working to help vision across the globe, they do that. And I've seen the glasses there. They sponsor a Texas Lions camp in a residential summer camp in Kerrville for children who have physical disabilities. The Garden Ridge Lions, with their generosity, compassion, and historic tradition of kindness, they are an outstanding example for all Texans to follow. And I'm so proud they are in Senate District 25. In the gallery, we have them right here. I'm pleased to be able to take the mic and welcome you to your Texas Senate. Members, please help me welcome the Garden Ridge Lions Club.
Following motion in writing, the Secretary will read the motion.
Motion in writing. Mr. President, I move that the nomination of Horatio Pena as judge of the 476th Judicial District Court in Hidalgo County be withdrawn from the Committee on Nominations, and I further move that the nomination be returned to the governor pursuant to his request. Motion by Senator Campbell.
Is there an objection to the motion? Hearing none, motion is adopted. Chair recognizes Senator Campbell for an announcement on nominations.
Thank you, Mr. President. Mr. President and members, the Senate Committee on Nominations action report from our meeting that was held on Monday, March the 13th, has been placed on your desk. In accordance with the Senate rules, this report will be eligible for consideration tomorrow. Thank you, Mr. President, and thank you, members.
Members, that concludes the morning call. Senator Schwertner, for what purpose? Chair lays out on third reading and final passage of Senate Bill 2. The Secretary read the caption.
Senate Bill 2, relating to conduct constituting the criminal offense of illegal voting.
Members, we're going to back up. So Senator Hughes is recognized for a motion to suspend the regular order of business on Senate Bill 2.
Thank you, Mr. President. Members, I move to suspend the Senate's regular order of business to take up and consider at this time Senate Bill 2, the bill we passed on second reading yesterday. It restores the law to what it was before 2021 to adjust for an amendment that was added to a bill late in the process, and also to correct a court opinion. That's what the bill does, and I move suspension.
Senator West, for what purpose?
Question of the author.
Senator Hughes, do you yield?
Of course, I'll yield.
Thank you very much, Mr. President, members. Senator Hughes, yesterday during the lengthy discussion, we were talking about provisional balloting. And what is the status if someone does a provisional ballot? Are they subject to this particular prosecution under this law?
Well, thank you, Senator. This is worth discussing because I want to make sure I'm sticking to the language of the bill. I think I can answer your question. Now, the current statute, 64.012, illegal voting, basically, I'll just read exactly what it says. Subsection C says, a person may not be convicted solely upon the fact that the person signed a provisional ballot affidavit under section 63.011 unless corroborated by other evidence that the person knowingly committed the offense. Now, that's the quote from the current statute. Senate Bill 2 does not amend that language at all, as you know. So that's what we're talking about on provisional ballot.
So a person can be prosecuted if there's a provisional ballot and there's corroborating evidence of the commission of another offense, to wit, the offense subject to this particular section. Is that correct?
Yes, sir. And that's the law today and also after Senate Bill 2, should it pass. I believe that's correct.
All right,
I think you're reading that right.
So if there was any misunderstanding yesterday that a person submitting a provisional ballot affidavit could not be prosecuted in this section, this clears up this clears that up, right?
I believe so. The signing of that affidavit in and of itself, because as you know, when you sign the affidavit, you're swearing that I'm eligible to vote in this location. I'm not been convicted of a felony, or if I have, I've completed my terms and haven't been found incompetent, had my voting rights taken away. So when someone signs that provisional ballot application, they are swearing to that. And this section of the code, added last session, says that act in and of itself, by itself, is not enough. There has to be corroborating evidence.
Of another offense?
Well, of the offense of anything in this list of illegal voting. Yes, sir.
All right, so then a person could, theoretically, if a prosecutor decided, your language becomes law, they could be prosecuted even if they executed a provisional ballot affidavit. They could be prosecuted under this particular law if a prosecutor decided that there were facts substantial enough to bring
I believe that if there's, go ahead, I'm sorry.
Well, if a prosecutor believed that there was probable cause to bring a case.
There was corroborating, if it was corroborated by other evidence that they knowingly committed the offense. Yes, sir. I believe you're reading that right. That's correct.
Okay, so, all right. So I just want to make sure we cleared that up, because yesterday I thought you had said that if a person did a provisional ballot that they would not be prosecuted under the statute. That's not correct.
No.
Let me finish. If indeed a prosecutor thought there was probable cause that under the new statute that they had committed an offense, they could be prosecuted even if they had just executed a provisional ballot, correct?
Senator, that's exactly right. And I want to make sure I'm sticking to the language of the statute. You are correct. You're reading it correctly.
Okay. All right. Thank you.
Thank you, Senator.
Senator Menendez, for a purpose?
Mr. President, will the gentleman yield for a question?
Do you yield?
Of course, I'll yield.
Thank you. Senator Hughes, yesterday, and I think just a few minutes ago, you stated that this was, you were simply trying to rectify a mistake that was caused last session. And if I understand correctly, now this is where I'd like clarification. In the second special session on Senate Bill 1, an amendment was added that reduced the penalty by Representative Steve Allison, a Republican from Bexar County. Is that not correct?
I believe that's correct. And if I don't think I used the word mistake a moment ago, but it was, the amendment was added late in the process. And I don't know what the state of mind was, but yes, it was an amendment added in the House at the very end. And I believe Representative Allison offered the amendment.
Yes,
I believe that's right.
Amendment was added late in the House, but didn't that amendment cause the bill, Senate Bill 1, to go to conference?
No, sir. The bill was going to conference already. because the Senate wanted to remove another amendment that had been added, and so the bill was already on its way to conference.
So you just stated that the bill was going to conference so that you could remove another amendment, correct? So at conference, wouldn't you have been able to remove this amendment, the one that reduced the penalty?
Well, Senator, if you review the debate on this amendment we're discussing now, it was the substance of a bill that had been offered during the regular session and during the special session. But for some reason in the second special session with this amendment, the bill itself language was amended to include this lowered offense. That was not discussed when the amendment was laid out, was not discussed when the author of the bill, Representative Murr, accepted the amendment.
So the amendment's accepted, but the bill still goes to conference, correct?
That's correct.
So the bill goes to conference, and just for the purposes of people not familiar with the process, at that moment, there are 5 conferees. Were you the chair of that conference committee on the Senate side?
I believe I was the chair on the Senate side. I believe that's right.
So then you and the other 4 conferees have the capacity in conference committee to strip any amendment that you want, don't you?
Well, we can on the Senate side. We cannot force the House to comply. As you'll recall, Senate Bill 1 had been the source of quite a bit of attention. Some of our friends in the House left the state, causing another special session. And so it was delicate. And by the time the language buried in this amendment was discovered, it was real late in the process. There was a lot in Senate Bill 1 that the Senate agreed with, that the House agreed with. So the decision was made to move the bill, knowing we could come back and address this amendment. And as you may recall, the Senate, in the next special session, passed a bill to remove this amendment. So this is not the first time the Senate has addressed this.
But nevertheless, the capacity was there for you to request this amendment to be removed at conference, but it was not removed at conference, correct?
I wish the amendment had been caught earlier in the process, and that's why we're here now, because as you know, we meet every 2 years or more often sometimes to continue and clean up and make improvements and learn from experience. So that's what we're doing today.
Thank you for taking my questions.
Thank you, Senator.
Thank you, Mr. President.
Thank you, Senator. Senator Gutierrez, what purpose?
No, just for a couple of questions.
Do you yield?
I'll yield.
Senator Hughes, thank you, Mr. President, first off. Senator Hughes, we had an at-length discussion. I don't want to delay things any further. Just want to reiterate one thing. Since the last election, in the last election in your county, in Mineola, or any other county, was there any illegal voting that led to any kind of indictments, or rather informations filed, because it would be a misdemeanor? Any informations filed across the state that you know of?
I believe there are investigations taking place, but I don't know if anything's been filed. If you know, let me know. I don't know the answer.
No, I don't know. I don't know any. As a matter of fact, I think it's 0. So no.
Now, do you think it's 0 or you don't know? Because those are different things.
Yeah, I think it's 0.
You think or you know it's 0?
I think
Since we're talking to the Senate, we should be careful of the information we share. Make sure it's accurate.
For sure. But you and I read the paper, and I haven't heard of any such thing, right? And so here we are. And this is a burning issue to you to change this from a misdemeanor back to a felony.
Like it was for 50 years almost.
Absolutely. But times change, and legislatures make changes when things need to be changed. And indeed, Representative Allison, this was part of a deal. I don't need to rehash what Senator Menendez has suggested, but you were on the conference committee. There's just a handful of people. And yesterday, you kind of made it seem like this was something that just kind of got through there surreptitiously, that caught us all unaware. But this was debated in that second special session.
No, sir, it was not.
Talked about.
No, sir, it was not.
Not in this room, but in the conference committee. You talked amongst yourselves. You have a green document that you all signed. You did read it, right?
I read it pretty carefully.
Why did you sign off on it?
Senator, as I mentioned before, by the time this amendment was discovered in the House and the Senate, the process was so far along, and there was so much work in Senate Bill 1 that everybody on this floor and on that floor worked on. The decision was made to pass the bill and get the good policies in place and come back and to address this. And as you know, as you may recall, we were here in the next special session, and the Senate passed a bill correcting this amendment from Senate Bill 1 that we're discussing today. The Senate passed that, the House did not, so now we're back.
But to your
number, and I would say this, Senator, it might help you to know, a number of members of the House have filed bills to do this very thing, to restore that penalty to the felony. It had been a felony for almost 50 years.
Yeah. But again, and lastly, to your knowledge, no undocumented immigrants voted illegally, or let me change the question and make it so simplify it. There were no informations to your knowledge that were filed for undocumented immigrants illegally voting. That was one of the fact patterns you put up.
Well, the question was asked about illegal voting and whether non-citizens had the right to vote. I was responding to questions. I don't think there's a dispute about whether only citizens get to vote. Do we agree on that?
My question to you is very simple.
Do we agree on that, Senator?
My question to you is very simple. Are you aware of any informations that were filed by undocumented immigrants for illegally voting in the last election?
I know there are investigations ongoing. I don't know about the state of any prosecutions.
Okay, and we can talk offline about those investigations because I haven't heard of any. Are you aware of any informations that were filed for felons that, because that was your other fact pattern, that voted in the last election cycle?
Now, Senator, they weren't my fact patterns. I responded to questions from senators, and they gave me fact patterns, and I responded like I'm trying to do here. I know there are investigations going on. I'm not aware of the status of any prosecutions. If you know something, let me know.
These weren't fact patterns from other people. You put out 3 scenarios. You said if you voted in another state, if you were a felon and you couldn't vote, or if you're not a citizen of this country. Those not anybody's fact patterns, but I don't need to be argumentative.
That's the law, Senator. That's the law on illegal voting.
Absolutely. Are you aware from this last election cycle of any felons, any informations filed for any felons illegally voting in the last election? Are you aware of any?
I know investigations are ongoing. I'm not familiar with the status of any particular criminal prosecutions. And if you have any, let me know. I don't know.
None that I know of. How about out-of-state people that voted in another state, came to Texas and voted? Winter Texans, I don't know. You name it. Are you aware of any informations that from the last election across this state? And that's my last question.
I don't know about the status of prosecutions. There's a big discussion about folks being registered in multiple states and voting in multiple states. There's going to be some other legislation about this. Many states are looking at that issue, but I'm not sure about the status of any prosecutions today.
You're not aware of any. Thank you, Mr. President. Thank you, Senator.
Thank you, Senator Gutierrez. Senator Bettencourt, what purpose?
Ask questions of the author.
Do you yield?
Of course, I'll yield.
Thanks, Senator Hughes, for bringing this bill and for the explanations. There is a major investigation underway in Harris County.
I've read about that.
Where both the governor and also the district attorney, people of both political parties, have asked the Texas Rangers to come down and investigate what happened on November 8th, 2022, due to the fact that the election process, quite frankly, nearly broke down. And we have, by reports from one news source, KHOU 11, it identified 121 polls that had paper ballots that weren't delivered in a timely fashion or at all. And you wonder if the election administrator either couldn't or wouldn't get that paper ballots out. But the point I'm making here is there are now 21 active election challenges in Harris County. And they are literally going to be bringing, people in to discuss voting because clearly the people that were turned away from the polls, that's voter suppression, plain and simple. When government puts on an election and doesn't have ballot paper for everybody to vote, it is voter suppression. So there's going to be literally hundreds of people discussed and deposed, I assume, in these, and we don't know where these investigations are going to lead to. As somebody that used to be a voter registrar, we'd have to fill out, the documents by state law about allegedly voted twice. These are complex investigations because many times, government makes an error. Well, at a minimum, government made the most preposterous error I've ever seen in my life for the nation's third largest county to have a third world election, which is put on election and leave millions of sheets of ballot sheets in the warehouse and not bring it to the polls. So we don't know what we're dealing, but we have active Texas Ranger investigations requested by a Democrat DA and a Republican governor, and we don't know where that's going to lead. But I wanted to make sure that part of this discussion is talking about a recognition of the obvious. When you have a chaotic election, anything can happen, and we just don't know what's going to happen until those 21 election contests are reviewed. Did you agree with that?
That's important, Senator. Thank you for pointing that out. We get a lot of questions about that because there were so many irregularities and so many questions that were asked.
All right. Thank you.
Thank you, Senator. Senator Miles, what purpose?
To Senator Betancourt and then to the author.
Yeah. Yeah, it's not in order for you to question another senator on the floor, only the bill author.
Okay, then I'll just go to the author.
Do you yield?
Yes, of course I'll yield. Yes, sir.
Senator Betancourt's story that he just told you is absolutely correct. There is a major investigation in Harris County. It has to do with ballots not being delivered to the clerk's office on time, more so than, I don't know of any claims whatsoever of people voting twice. I don't know of any claims in the investigation that he's talking about of anybody voting who was not supposed to vote. The investigation is purely on why ballots didn't get to the clerk at the end of the voting period, and they got there later. And it's a tragedy, Senator Betancourt. But if we're going to tell the story, let's tell the story exactly how it is. There's no claims of fraudulent people of the one person voting twice. There's no claims of a person who is not qualified to voting. It's simply about the delivery of ballots. So let's make that clear. Thank you, Mr. President. Thank you.
Thank you, Senator. Senator Hughes? Motion to move on suspension. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Creighton, Eckhart, Flores, Gutierrez, Hall, Hancock, Hinojosa, Huffman, Hughes, Johnson, King, Colcourse, Lamantia, Menendez, Middleton, Miles, Nichols, Parker, Paxton, Perry, Schwertner, Sparks, Springer, West, Whitmire, and Zaffarini.
The vote is 19-12 in favor. The rules are suspended. Chair now lays out on third reading and final passage Senate Bill 2. Secretary will read the caption.
Senate Bill 2 relating to conduct constituting the criminal offense of illegal voting.
You're recognized on final passage.
Thank you, Mr. President. Members, thank you for your time yesterday and today. Senate Bill 2 does two things. It restores the penalty for illegal voting to a felony. It's been a felony for almost 50 years, goes back to 1975. The second part of this bill restores what Texas courts had held for over 100 years, that knowledge of the facts that make me unqualified to vote are sufficient. If I know I'm not a citizen, if I know I'm a felon not completed my terms and I vote, that is sufficient. That's been the law in Texas from the Court of Criminal Appeals, from multiple courts of appeals for 100 years. That was recently called into question by a ruling. Senate Bill 2 restores the law on those 2 points. That's what it does. That's all it does. It makes sense. I thank you for your support, and I move final passage.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Creighton, Eckhart, Flores.
There being 19 ayes and 12 nays, the bill is finally passed. Thank you, Senator Hughes.
Thank you, members.
Senator Hughes, you're recognized for, for a motion to suspend the regular order of business on SCR 17.
Thank you, Mr. President. Members, I move to suspend the Senate's regular order of business to take up and consider at this time Senate Concurrent Resolution 17. SCR 17 has to do with the U.S. Supreme Court. Now, just briefly, we'll recall there are two methods for proposing amendments to the U.S. Constitution. We can call on Congress to propose specific amendments to the states for ratification, or Congress can call a convention of states to propose amendments. We're going to have some legislation about that later. This resolution would be the state of Texas calling on Congress to propose this amendment. It's the Keep 9 resolution. So since 1869, the Supreme Court of the United States has had 9 members. Now, in April of 2021, legislation was introduced to expand the Supreme Court from 9 to 13. And with recent Supreme Court decisions, the call to increase the numbers to pack the court have only increased. This is nothing new. This was tried back in the 1930s, and it was also rejected then. And so, again, this urges Congress to propose this resolution to keep 9 justices of the U.S. Supreme Court. Court packing from the left or the right should not affect our Supreme Court. Let me give you a quote, and I'll go to my seat. This is a quote from a Supreme Court justice. I'll let you guess which one. 9 seems to be a good number. If anything would make the court appear partisan, it would be that. One side saying, when we're in power, we're going to enlarge the number of judges, so we'll have more people who will vote the way we want them to. So I am not at all in favor of that solution to what I see as a temporary situation. That quote from Justice Ruth Bader Ginsburg. You see a very similar quote from Justice Clarence Thomas. Those two didn't agree on much, but they agreed on this. Let's don't politicize the court. Let's keep it where it needs to be, out of politics. So this simply calls on Congress to propose for our ratification the Keep 9 resolution, and I move suspension.
Senator Hinojosa, what purpose?
Well, Senator Hughes, yield for a couple of questions.
Do you yield?
Of course I'll yield.
Thank you, Senator Hughes. I support SCR 17, but I do have some questions to ask. I disagree with saying that the court has not been politicized. Pretty much it's become very politicized on its own, by the way. And I know throughout history, we've had 9 justices in 1879, I think.
69, somewhere around there, yes, sir.
I think it's 1869.
Yes, sir.
And what is the main reason that Congress usually tries to change the number of justices in the United States Supreme Court?
Historically, Congress has discussed changing the number of justices when the justices make rulings that Congress disagrees with. So that with Congress, if you have Congress and the sitting president held by one party, and the U.S. Supreme Court's doing things they don't like, that's when we hear this proposal, well, let's add some more justices who will agree with us so we can dilute those 9. And this could come from the left or the right. But that's my understanding. Wouldn't you say this comes up when Congress or the president don't like what the Supreme Court is doing?
So I guess the real reason is for political reasons. One party is in power, controls both the Senate and Congress and the office of the president. They don't like the decision being made by the Supreme Court. They try to change the number.
Yes, sir. That's right.
And the last time they tried to do that was in, I guess, President Roosevelt was the president, and he failed.
Yes, sir.
You know, I support tradition, and I really support the 9 justices, but I just want to make sure that Congress still has the authority and power to change the jurisdiction of the Supreme Court. Is that correct?
Yes, sir. Without this amendment, the Congress can make a lot of changes. As you know, they can't take away a judge's job after they've been put in place without impeachment, but they can adjust the jurisdiction of the courts. They can change the number of courts. Congress has, I believe you're right, under the Constitution, Congress has broad authority. Now, this amendment would limit that authority to say that Congress cannot change the number, couldn't make it larger or smaller, but would have to keep it at 9. But you're right, without this amendment, they have a lot of authority there.
And of course, as you well know, many times during the process in the Texas Senate, in the United States Senate, sometimes one party outmaneuvers the other party. And I think in this situation, the Democrats, quite frankly, got outmaneuvered by the Republicans. But that doesn't change the fact that traditionally, historically, we have had 9 justices. We want stability, continuity. I do not agree with all of the decisions at the Supreme Court, but I do agree they ought to keep it at 9. So thank you so much, Senator Hughes, for answering my questions.
Thank you, Senator.
Senator Gutierrez, what purpose?
For a few questions. Mr.
Do you yield?
I'll yield.
Thank you, Senator Hughes. My question's really, and I know that the body on both sides of the aisle, or really the Democrats, are on different sides as to whether it's 9 or 13 or whatever that number might be. This has nothing to do with ratification of the United States Constitution, because there's a different process for that, correct?
Ratification of amendments to the Constitution or
you can't ratify the Constitution. In other words, we can't do anything on the Supreme Court or have this kind of amendment mean anything, in other words, unless Congress by 2/3 says we're going to have a congressional. In other words, you cannot modify the United States Constitution, specifically Article 3.
Well, this would begin the process. Right? We're asking Congress to propose these amendments to the states for ratification. So you're correct. But I think we agree, by the Texas Senate and the House passing this resolution, we don't freeze that number at 9. We just call on Congress to propose that resolution to go through the process to amend the U.S. Constitution. You're correct. This is just one step.
But we would first have to do 2/3 of the House of Representatives in Washington and 2/3 of the United States Senate in Washington before any kind of constitutional convention to be called, correct?
Well, and we're not asking for a convention. We are asking them to propose this individual amendment to the states for ratification. As you know, the 27 we have all came that way. We haven't done the convention yet.
Yeah.
But this is not about a convention. I'm glad you asked. Okay. This is a proposal of this amendment to the states for ratification.
But again, you would still require 2/3 of the U.S. House and 2/3 of the U.S. Senate, correct?
Yes, sir. With this resolution, we are asking them to do that.
All right, fair enough. Why do we have 9 justices on the Supreme Court?
Well, it started, wasn't always that way. It's been 9 since 1869. Having an odd number is obviously a good idea since they have to vote like we do here. Beyond that, if there's a magic to the number of 9, you share with me what you know. I just know it's been 9 since 1869.
It was 10 once, wasn't it?
The numbers fluctuated, and if you say 10, I believe you.
It was 5 before as well.
Okay.
Would it surprise you that in 1869 we had 9 circuits?
Wouldn't surprise me. I don't know, but it wouldn't surprise me.
How many circuits do we have now, Senator Hughes?
I know we're in the 5th. That's the one I pay attention to. I don't know how many we have.
You know, we have the 1st through the 11th, so that's 11. And then we have the D.C. Circuit Court, and then we have the Federal Circuit Court.
Yes, sir.
And so that's 13. Would it surprise you to think that they chose 9 in 1869 because there was 9 circuits?
Wouldn't be surprising. As you know, today, each member of the U.S. Supreme Court is assigned a circuit for which they have primary responsibility. I don't know who ours is. You may know.
All right. Thank you, Senator Hughes. I have an amendment that we'll talk about when we get beyond suspension. Thank you.
Members, the motion is on the suspension of the regular order of business on SCR 17. Is there any objection? There are objections. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Creighton,
There
Eckworth.
being 26 ayes and 5 nays, the suspension is adopted. Rules are suspended, excuse me. Chair lays out the following resolution. The Secretary will read the resolution.
SCR 17, urging Congress to propose and submit to the states for ratification the Keep 9 Amendment to the U.S. Constitution.
Members, we have an amendment, the following amendment. We'll let it be passed out here for a moment before we read it. Secretary will read the following amendment.
Floor Amendment number 1 by Gutierrez.
Senator Gutierrez, you're recognized on your amendment.
Thank you, Mr. President. Mr. President, members, this amendment is really quite simple. It has 4 elements. Number 1, it would require mandatory recusal from any Supreme Court justice on cases involving previous clients or employees of a justice's family member. A lot of our courts judges today would automatically recuse themselves. I think that we need to have the Supreme Court do the same. I don't know about y'all, but this notion of lifetime appointments is just preposterous. So I'm suggesting 12-year limits. I'm open to anybody that wants to change that to any other specific number. Number 3 is a prohibition on eligibility to be a Supreme Court justice if the justice or the justice's family member has ever participated in an insurrection against the federal government. We've seen some evidence of that by a member of the family of one of the justices. I think that we all hold this country dear to our hearts, and we hold this union dear. And lastly, I think that it's pretty benign here. We should have financial disclosures of the judge's sources of wealth. And so that's my amendment, Mr. President. I think I'm glad to answer any questions if anybody has any. And otherwise, I move adoption.
Senator Hughes on the amendment.
President, thank you. I won't go through point by point. I will note that federal judges already have extensive financial disclosure rules, much more thorough than the ones put on state government. Each of these matters is already addressed in law, to my knowledge. I'll be voting no.
Members, the motion is on the amendment. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Creighton, Eckhart, Flores, Gutierrez, Hall, Hancock, Hinojosa, Huffman, Hughes, Johnson, King, Colcourse, Lamantia, Menendez, Middleton, Miles, Nichols, Parker, Paxton, Perry, Schwertner, Sparks, Springer, West, Whitmire, Zaffarini,
Members, we're just checking to see for one member who's not here if they wish to cast their vote. There being 10 ayes, 21 nays, the amendment is not adopted. Fails. Taylor? Senator Hughes, you're recognized for a motion.
Mr. President, I move adoption.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Creighton, Eckhart, Flores, Gutierrez, Hall, Hancock, Hinojosa, Huffman, Hughes, Johnson, King, Colcourse, Lamantia, Menendez, Middleton, Miles, Nichols, Parker, Paxton, Perry, Schwertner, Sparks, Springer, West, Whitmire, and Zaffarini.
Being 26 ayes, 5 nays, the resolution is adopted. Thank you, Senator. Senator Birdwell.
Senator Hughes, you're recognized for a motion to suspend the regular order of business and take up and consider Senate Bill 559.
Thank you, Mr. President. Members, I move to suspend the Senate's regular order of business to take up and consider at this time Senate Bill 559. Members, this is about the First Amendment, about free speech, free exercise of religion. And that amendment states in part, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech. And it goes on from there. This has to do with lawyers. Not very popular. I realize a few lawyers on this floor, Senator. That's right. But lawyers don't always poll that well. But I think we recognize that lawyers are an indispensable piece of our system of justice, our system of government, to advocate for those whether their clients are popular or not, whether their clients are in the majority or not. The lawyer's role is important. And so we want to make sure that in Texas, lawyers aren't compelled by the state to give up their constitutionally protected rights of free speech and freedom of religion. Now, the American Bar Association has proposed a model rule for state bars to adopt, and it would clearly limit the free speech of many lawyers of faith and of various faiths. We're not favoring any one over the other. As recently as 2020, the Texas State Bar considered this rule and so far has not adopted it. But if Texas were to adopt it, lawyers could lose their licenses based on statements that were not actually known to be or intended to be harassing or discriminatory, simply because someone might construe their statements or their actions in that way. Here's the activities that would be caught up by a rule like this: participating in a panel discussion or conversations that touch on controversial political, religious, or social viewpoints, serving on boards of various religious or other charitable institutions, and then, of course, speaking at public events. Now, discriminatory behavior by a lawyer is already prohibited, and that's not changing. That's not changing at all. This is about folks who have sincerely held religious beliefs, as that term is understood in the law, being protected. Now, this is not just a hypothetical. This has happened in at least one state where a lawyer was punished because of the client the lawyer chose to represent. I think every lawyer and every American realizes how offensive that should be to us. So, Senate Bill 559 is preemptive, and it makes sure that in Texas, our state bar will not adopt this model rule from the ABA or anything like it that would limit free speech, free exercise of religion. If a person comes to the state bar based on a complaint regarding their speech or conduct or judicial proceeding, this gives a defense to losing their law license. It does not let anyone violate federal law or Texas disciplinary rules of professional conduct, and it doesn't keep someone from being fired or sued or arrested. There's still going to be consequences to speech. That's how the system works. But attorneys should not fear losing their licenses or potential attorneys being denied a license based on their free speech, their free exercise of religion. And that is what the bill does, and I move suspension of the regular order of business.
Senator Hinojosa, for what purpose?
Will Senator Hughes yield for questions?
You yield, Senator Hughes.
Of course I yield.
You recognize Senator Hinojosa.
Thank you, Mr. President. I guess my question pertains, right now, an attorney can reject any case of any client or a person who wants to become a client that comes before the attorney. Is that not correct?
That's correct, Senator. A lawyer has that right, and that's not affected by this bill. But go ahead, please.
And I support freedom of speech and certainly freedom of religion. But I do not know one instance where the state bar has denied a law license to someone based because they're a Muslim, Catholic, Jewish, Protestant, or Buddhist. Do you know of that? Any case?
Well, Senator, the State Bar of Texas, thankfully, has not chosen to adopt this rule. It was brought up and considered, and so far they have chosen not to. But we know of one case in the United States from 2018. I can't say that there aren't others, but we know of this one. And this had to do with a law firm called Brenna, Bell, and Clarkson. Now, they represent a client. And let me tell you about I think this may answer your question. This may help answering your question. So there was in their city, in Anchorage, there was a group called the Downtown Hope Center. It was a religiously affiliated women's homeless shelter. And they helped women. They they accepted only women for various reasons, for privacy and that sort of thing. They served women only. They got
specialty law.
Yes, there you go. That's right. And so they got into a problem, this homeless shelter, because, and this is a sensitive topic, but someone who was a biological male, someone who was born a male, but now identifies as a woman, wanted services, wanted to come and stay at the shelter. And they said, we cannot let you come because the women here, the biological females, don't want that. This is only for them. So they were sued. The lawyer that represented the homeless shelter, was brought up for discipline based on that. Now the state backed off. The state backed off when they got other lawyers involved. But this is one case we know of where a lawyer representing an unpopular client was getting in trouble for that. So I think we're on the same side here. This is not to limit who a lawyer can represent. This is to protect a lawyer's right to represent popular clients, unpopular clients, wherever they are.
Well, in many years of practice and my interaction with other lawyers and law firms, a law firm or an attorney has the absolute right to reject a case.
Yes, sir. That's right.
Does a lawyer have that right?
Yes, sir. That's correct. I agree with you. That's right.
So I try to just narrow down what it is that you're trying to address. I know we have the Texas Religious Freedom Restoration Act in place that provides quite a bit of protection to the general public. So how would your Senate Bill 559 differ from what is required by law right now under freedom of religion in the Constitution and also under the Restoration Act?
Well, thank you. These protections are stronger than those in the Religious Freedom Restoration Act. And again, this only applies to the State Bar of Texas, affecting a lawyer's law license, their right to advocate for their clients, and of course to make a living. So this is more protection than is offered by the Religious Freedom Restoration Act.
So in what state did that case you just quoted a while ago happen?
Yeah, that case in 2018 was in Alaska. You know, many states have looked at this ABA rule. Texas has not adopted it, and we don't want the State Bar of Texas to adopt this rule to enable that kind of discrimination. So this is a preemptive measure. This is not happening in Texas as far as we know. We want to make sure the State Bar of Texas isn't weaponized against lawyers of faith, whatever their faith may be.
Well, I would imagine if they did that, probably those who were elected to represent the State Bar would be taken out of the public office. I'm going to go ahead and vote for your bill. I just wanted some of my questions answered because I do have some concerns about statements that have been made that this would allow lawyers to discriminate, and I don't think such a case. I just really think that there's always a risk of getting sued, as you well know, when you take a case and you end up with a client that's never happy, or you have a client that's just a chronic problem in terms of issues that doesn't want to follow the lawyer's advice. I mean, I've been through all that, so I'm going to go ahead and vote aye on your bill.
Thank you for your questions, Senator. Those are important. Thank you for that.
Thank you, Mr. President.
Thank you, Senator Hinojosa. Senator Gutierrez, for what purpose?
Just a few questions.
Do you yield, Senator Hughes?
I will yield.
You're recognized, Senator Gutierrez.
Thank you, Mr. President. I'm equally confused because you've already stated that there was a Colorado cake company. Remember that? They were selling cakes, and there was a Supreme Court decision. The Supreme Court said, you don't have to sell your cake to a gay couple if you don't want to. Do you remember that?
I do.
All right. We're both lawyers. I mean, you're a far more qualified lawyer than I am.
See about that.
You're just brilliant.
We'll find out, but go ahead.
You're just brilliant. Well, in that Colorado cake decision, the Supreme Court said they don't want to sell their cakes to somebody, they don't have to sell their cakes, right?
Yes, right.
Because for whatever reason, that's fine. They can refuse service to anybody. You as a lawyer and myself as a lawyer, we can refuse service to anybody, right?
That's correct.
And so I'm just trying to figure out, as was Senator Hinojosa, what it is that we're trying to do. Is this about hiring in our law offices?
Senator, that's a great question. I'm glad you asked because it really is important. This is not about a lawyer's ability to refuse or accept a case. That already exists. That's not being changed. You are correct. This is about a lawyer who engages in the practice of law, but then goes to lecture at a law school or speak on a panel or make remarks. And maybe those positions that lawyer takes are offensive to some people, maybe based on his religion. That's the idea. So this is not about your ability to refuse a case. And so I appreciate the reference to the California cake baker. That was an important case, but this is not about that at all. And I really do appreciate you asking that.
Well, no, but my question was, is this about hiring in the law office, let's say,
No,
for
sir.
instance?
It is not about hiring in the law office.
Let me give you a fact pattern.
Sir?
Let me give you a fact pattern. Well, not a fact pattern, just a question first, and then we'll go into a hypothetical. You believe in, you're a Christian? You're a Christian, correct?
You might not believe that to look at my life some days, but yes, I'm a follower of the Lord Jesus.
I know you're a Christian, I'm a Christian. Ephesians, do you agree everything that's in the Bible?
Every word of the Bible comes from God, no question about that.
So, but do you agree with everything that's in the Bible?
Yes.
Okay. I'm a cafeteria Catholic, so I choose to pick and choose what I want.
I think a lot of us do that, whether we admit it or not.
Ephesians says that ladies, wives should submit to their husbands. My wife, you don't want to know what she thinks about Ephesians 5:22, but I submit to my wife every day. You know, we're an equal couple. But if you've got a lawyer that devoutly believes that women should submit to their husbands, and that same lawyer fires this gal that's in his office for being an unmarried woman, and he finds out that she's done this and this, and his religion says that she's a harlot, whatever. Is he exempt from liability for his actions with his employee? Is that what we're trying to do here?
That's a great question. I want to make sure the record's clear. You know, Ephesians 5 also says in that same chapter, it's an important part that goes along with the verse you read. It also says, husbands, love your wives as Christ loved the church and gave himself for it. I know you know that. That's a high standard for us to live up to as husbands as well.
Absolutely.
But to answer your question, no, that would not, this fact pattern you gave would not be implicated by this bill. This does not have anything to do with suits for discrimination or crimes of discrimination where those exist. That's not what this is about.
So it's not about hiring. It says specifically in the model rule, status in conduct related to the practice of law. And so what you're suggesting is that if I'm in a panel and I say something that someone misinterprets, then I will be protected under your...
Senator, that's the idea. If you take a position on marriage, for example, and you say publicly, and you're a member of the bar, you're a lawyer, and you say, I believe under U.S. law, under Texas law, that marriage is between one man and one woman. That is a controversial view in some places. It's believed by perhaps still a majority of Texans, but that's controversial in some places. And so as a lawyer, you should not be punished or feel in jeopardy of your law license because you take that position. It's based on your sincerely held religious beliefs, as it is for many people. There's many people in this building. I'd say the majority feel that way.
There's even a clause in here that says, this paragraph does not preclude legitimate advice or advocacy consistent with these rules. What's the number one rule of us as lawyers? What's rule number one?
We represent our client's interest, but there's...
What's that word? Starts with a Z.
Zealous advocacy. Is that the one is that the one?
Zealous advocates. And so right here, this says, hey, listen, if I'm going to court, and I'm not going to even bring up a county in Texas, because there are no racist counties in Texas, I'm sure. In our imaginary racist county in Texas, if you were in front of a jury and you were representing a white man who had killed a black man, and you had to kind of pull at the heartstrings of those very racist imaginary Texas County residents, you could be a racist under this model rule. You could say things that might be perceived as racist, couldn't you, under this exception?
Well, Senator, as you know, this is based on sincerely held religious beliefs, and that term has been pretty fully litigated. But the concern you raised, I think you got to the heart of the matter. It's how those statements are perceived. Depending on what's said, it's beyond your control how people will perceive statements that you make. And that's really a big part of the problem with the ABA rule, because it's completely open-ended. We talked yesterday a lot about mens rea and due process, and notice, as you just pointed out, as you just demonstrated, this ABA rule is a real problem for all those reasons.
You talked about the ABA rules. They're called model rules, right? Why are they called model rules of professional conduct?
They propose them for state bars to adopt to apply to lawyers in those states.
You're a pretty high profession, and I know most of you might not think that, especially non-lawyers might not think that this is a high profession, but I believe I went to law school because I was in search for the truth. I imagine you did too. And so I know a lot of lawyers, and you're included, and lawyers are good people. I think that this rule by the ABA is about making sure that everybody acts the right way. So respectfully, I'll be voting no.
Senator Menendez, what purpose?
Thank you, Mr. President. Will the gentleman yield for questions?
You yield.
Of course, I'll yield.
Thank you, Mr. President. Thank you, Senator Hughes. It is my understanding that this bill is seeking to address a 2016 model ABA, American Bar Association rule that has not been adopted here in Texas. Is that correct?
That's correct. Thankfully, it has not been adopted.
So you had mentioned in your question and answer with Senator Gutierrez that you felt that that rule was much too open-ended, much too broad. Did you not just say something similar to that?
I believe that's right. Yes, sir.
So as I read your bill, and others have read your bill, it concerns me as how broad the language in this bill that you are proposing. So I have a question. Under this bill, would the State Bar of Texas be able to take action if an attorney or a bar license applicant to discriminate based on race as a part of their sincerely held belief? Is that something they could do?
Well, Senator, discrimination is already addressed in a number of places, as it should be. And that's not what this is about. And this bill would not insulate anyone from civil liability, from a lawsuit, from criminal liability. And again, it's only based on conduct in the practice of law that's based on in the exercise of a sincerely held religious belief. As you know, Senator, free speech protects those unpopular opinions. Sometimes mine are unpopular, sometimes yours are. That's, as you understand, that's free speech. I didn't mean to lecture you, I'm sorry, but that's the idea.
That's quite all right. Senator Hughes, but my concern is that because of the language being so broad as to someone's sincerely held religious belief, and I know that you and I do not want anyone to be discriminated against, especially when they're seeking legal representation, would you be willing to accept an amendment that would ensure the bill would not have any unintended consequences infringing on a client's right to an attorney and due process?
Senator, let me be clear. This is not about accepting or rejecting representation. That's, if you look at the language, I think that's pretty clear. And to the extent that issue comes up, as Senator Gutierrez and Senator Hinojosa said, a lawyer today is free to accept or reject any client they wish. And if you think about it, if I'm coming to a lawyer for representation, if they don't want to represent me, I probably don't want them to represent me. I want a lawyer who's going to put their heart into it. So respectfully, that's not what the bill's about.
I noticed that there were a couple things the bill allows for. It says here, starting on line 56, or 55. As a defense in an administrative hearing or as a claim to defense in a judicial proceeding under Chapter 37 Civil Practices and Remedies Code, except that the person may not assert the violation as a defense to 1, allegation of sexual misconduct, 2, prosecution of an offense. Completely agree with those two. I just don't see why or how it would harm. I think it would improve this legislation, which I currently don't see the need for, but if it were to move forward, to add number 3, prohibits discrimination in representing an individual based on age, race, color, national origin, sex, gender identity, sexual orientation, or disability of the individual. Just trying to help your bill here.
Senator, under current law, a lawyer is free to accept or reject any client on any basis, and that's how it should be. Again, if I come to law you for representation and they don't really want to take my case, I don't want to force them to take my case. They're not going to be a very zealous advocate, as Senator Gutierrez said. So I suspect the lawyers would agree that we do not want to change that rule where a lawyer can say no to any client that they want. That's in the client's interest, that they don't get stuck with a lawyer who's not going to put their heart into the representation. Is that what you're talking about?
What I'm talking about is I'm concerned this religious freedom could be used as a shield to discriminate. So what you've said, that currently they can pick and choose whether they take a client, but does that apply to a public defender?
I've never served as a public defender, but again, if I'm a criminal defendant and a lawyer doesn't want my case, I don't want that lawyer representing me. I hope, and I think we agree on that.
Sure. Would this bill allow the bar, because I believe the language is broad enough to say that if a lawyer has their law license called into a question, would this bill allow for discrimination against the lawyer for their own, let's say their religious beliefs are out of sync with what our bar says they should be?
Well, Senator, you just got to the heart of the matter. The State Bar of Texas, the state of Texas, should not be in the business of saying we approve this religion, we disapprove that religion, if that's what you're talking about. I believe that really is the heart of the matter. As you know, lawyers of all people have to be able to take unpopular positions to represent their clients, and to those lawyers that wrote the Constitution were doing the same thing in many ways as far as taking positions that were not popular everywhere.
So the reason that you want to pass this bill is to protect Texas lawyers from a potentially bad American Bar Association rule. Is that what the heart of the matter is here?
Senator, I believe that's right. And by protecting lawyers, we are protecting their clients and the role that they play in the process. I believe that's correct.
I appreciate you taking my questions. Thank you.
Thank you, Senator.
Senator Eckhart, what purpose?
To ask questions of the author.
Do you yield?
Of course, I'll yield.
Thank you so much, Senator Hughes. This bill, I'm trying to unpack it to understand what we're really getting at, and one thing that concerns me is its effect on the good moral character standard that the state bar seeks to uphold. So talk to me about that some, because the good moral character standard is looking at the totality of the person in the courtroom and outside the courtroom to determine that good moral character. So I see very clearly that utterances of prejudice inside or in connection with an adjudicative proceeding would not be tolerated. But statements of bias, prejudice, obscenity, threat that don't rise to the level of protected speech, or perhaps rise is the wrong word. If a lawyer or someone who has applied to the bar has a well-founded reputation for these statements of bias, threatening statements, obscenity, how is it that the good moral character standard could be upheld given your proposed law?
Well, thank you, Senator. Great point. And so, as you described, this is about not just conduct in the courtroom, and that's what the ABA rule and the comments to the proposed ABA rule say. And that's really the issue, because if we're talking about religious freedom, if someone makes the statement, Senator Gutierrez and I were talking about the Bible, if someone, based on their sincerely held religious beliefs, makes a public statement that says, I believe that Jesus is God's son and he died for our sins and he rose again, and he is the only way our sins can be forgiven, the only way for us to see heaven and have a relationship with God. If someone states that as their sincerely held religious belief, there are people who will say, that's discriminatory. I don't believe that. That's narrow. You're saying there's only one way to heaven. That is discriminatory, or certainly could be perceived as discriminatory using the broad, open-ended language of this ABA proposed rule. That's one example, and it would apply to someone of the Muslim faith who made a statement, or any other faith. Again, as you know, we don't want the government in the business of deciding which religions are okay and which are not. I think we agree. That's the heart of the First Amendment.
Since I am the only non-Christian member of this body and a lawyer, I am grateful that my religious affiliation is not held against me by my government.
We both are.
Or by my state bar.
Yes, ma'am.
But your bill also, on line 38 through 41, says that the state bar may not burden an applicant or state bar members' freedom of speech or expression that is protected by the United States or Texas Constitution, including speech regarding a sincerely held religious belief, a political ideology, or societal view, and of expressive conduct. Now, I recognize that it says that is protected by the United States or the Texas Constitution, but in fact, free speech has limits. So one can go out and say, I incite you to storm the Capitol, and that's not protected speech.
Right. Fighting words, incitement to violence. What's the proverbial yelling fire in a crowded theater? Of course, you're right. Free speech is not absolute.
But I would think that it would be taken into consideration with regard to good moral character by the bar if someone stepped up to that line but did not cross that line, saying, I think that the federal government is a piece of junk and we should try to thwart it in every way we possibly can, even though they are the law of the land. Shouldn't the state bar take that into consideration? It's protected speech, but should this person be admitted to the bar to practice in the federal courts?
Well, that doesn't sound like a statement based on one's sincerely held religious belief, but I would say, as we all know, the right to criticize the government is definitely enshrined in the First Amendment, and I know we all know folks do it, and I'm sure if anybody looked at my social media at this moment, there would be no question about people's right to question and challenge and criticize the government, if that's what we're talking about.
I'm talking about somebody who is not inciting violence, someone who's simply saying, I don't believe federal laws should be respected. I believe that only state laws should be respected. They certainly have a First Amendment right to say that, but yes. Should someone who is very clearly saying that a body of law should not be recognized, shouldn't good moral character standard of the state bar consider that, even though they have a protected right to say that under the Texas Constitution? Do we really want lawyers who are saying very plainly they will not respect federal laws?
Well, Senator, it's a great question. As I read the bill and as I read the proposed ABA rule, that's not exactly what the bill's about. But I would say this, and I think we agree, even unpopular positions and unpopular speech are protected. And we were talking before about who a lawyer might represent. Someone who believes those things you're describing, I think we all agree they get representation. They get a lawyer in America. And so I think, especially on a topic like this, we want to err on the side of free speech.
I agree with you, but it appears from the wording of the bill that I 100% agree with you that people's freedom of speech should be protected. But there are limits to freedom of speech, and also a lawyer who has a well-documented, or a person who's seeking to be a lawyer who has a well-documented reputation of poor moral character based on their speech Shouldn't the state bar be able to take that into consideration?
Well, Senator, under the
Inside of a tribunal, they are well known to have these views.
Well, Senator, under the statute, nothing would preclude bringing such an action. This would merely say that the person would have the defense, and they would have to prove, of course, and the burden shifts to them to prove that this activity could comply, the statements or the expressive conduct complies with what's in the statute. So it still comes back to free speech and free exercise of religion.
I think everyone, of course, should have free speech and exercise of religion. I don't think that everyone should be a lawyer. Thank you for the response. I appreciate the back and forth.
Thank you, Senator. I do too. Thank you.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Creighton, Eckhart, Flores, Gutierrez.
There being 20 ayes, 10 nays, the rules are suspended. Chair lays out on second reading Senate Bill 559. Secretary, read the caption.
Senate Bill 559 relating to discrimination against or burdening certain constitutional rights of an applicant for or holder of a license to practice law in this state.
Members who have an amendment, Secretary will read the amendment. We'll get it passed out to you here.
Floor Amendment number 1 by Menendez. You're an aye on the bill? Okay.
We're going to wait for a second so the bill author can also read it. Senator Menendez, you're recognized on your amendment.
Thank you, Mr. President. Members, as you may have heard when Senator Hughes and I were talking back and forth, and I understand that he's now been very clear that we're trying to protect the poor lawyers of Texas from the American Bar Association and any passing any things. And it's fine. They should have a right to express their personal opinions and religions, and no one needs to infringe upon them. My biggest concern, though, is our constituents, especially those who may or may not be able to afford a private lawyer. They may have to rely on a public defender, and they may be accused of a crime that that person or a series of those public defenders in that particular county have a personal, religious, sincerely held belief that they would not want to defend. I think that this bill may inadvertently have the unintended consequence of hurting those least among us from being able to have due process. And so this simple amendment simply states that we will prohibit discrimination in representing an individual based on the age, race, color, national origin, sexual gender identity, orientation, or disability of that individual. I think that I am not a lawyer, so just so you understand. I've unfortunately been mistaken for one in the past, and I don't hold that against them. But, Sarah Hughes, I know that I've been told it would be unethical to a lawyer's duty. My understanding is a lawyer should not be deterred by any real or imagined fear of judicial disfavor or public unpopularity, nor be influenced by mere self-interest. And so I honestly bring this up not to derail your bill, because I understand what you're trying to do, protect the poor lawyers of Texas. I know that they need protection. I feel for you. Sometimes you're under duress and attack. I want to provide protections for the people of Texas who can least afford a lawyer and may need to have one from being discriminated against. And so that's why I bring this amendment, and I hope that you see it as a perfecting amendment to your bill, and I hope you would accept it.
Senator Hughes on the amendment.
Thank you, Mr. President. Senator Menendez, thank you. This is a line that I don't know has been addressed anywhere. Again, you don't want a lawyer who doesn't want to represent you. Respectfully, if I'm looking for a lawyer, I want one who wants to take my case. I don't want a lawyer who's been compelled to take my case, because if I do, I'm probably going to get what I paid for. This is a real issue. And again, it protects clients. It protects clients. As we know, lawyers have a history of taking unpopular cases. Remember the Boston Massacre? Well, we've read about it. John Adams represented those soldiers who had fired upon the colonists at the Boston Massacre. We could go through history, and I won't. Don't worry. We could go through history about lawyers representing unpopular clients with whom they disagreed. Lawyers have a duty to do that. To compel a lawyer to take a case they don't want is bad for that client. And respectfully, I'll vote no. Understanding the discussion, I believe this is really bad policy for clients. So respectfully, I'll be voting no on this amendment.
Member, the motion is on the amendment. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Creighton, Eckhart, Flores, Gutierrez, Hall, Hancock, Hinojosa, Huffman, Hughes, Johnson, King, Colcourse, Lamantia, Menendez, Middleton, Miles, Nichols, Parker, Paxton, Perry, Schwertner, Sparks, Springer, West, Whitmire, Zaffarini.
There being 11 yes votes and 20 nay votes, the amendment fails. You're recognized on passage to engrossment.
Thank you, Mr. President. Following on the excellent and hard work done by Senator Perry on this bill in previous sessions, and thanking the members for their indulgence, I move passage to engrossment.
Secretary will call the roll when ready.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Creighton, Eckhart, Flores, Gutierrez, Hall, Hancock, Hinojosa, Huffman, Hughes, Johnson, King, Colcourse, Lamantia, Menendez, Middleton, Miles, Nichols, Parker, Paxton, Perry, Schwertner, Sparks, Springer, West, Whitmire, and Zaffarini.
There being 22 yes votes and 9 no votes, the bill passes to engrossment, and we will hold there.
Thank you, Mr. President, and thank you, members.
You know, Senator Hughes, I'm seeing a pattern here. It seemed like we had a lot of debate with you and members in a regular session and 3 specials, and you're starting out like you finished for some reason.
Hopefully not in a prophetic way, Mr. President. Thank you very much.
Following motion in writing. Secretary, read the motion.
Motion in writing. Mr. President, I ask unanimous consent for Senate Bill 600 relating to increasing the minimum term of imprisonment for certain criminal offenses involving the smuggling of persons to be withdrawn from the Committee on Criminal Justice and re-referred to the Committee on Border Security. Author, Senator Birdwell. Senator Whitmire, Chair of Committee from which bill is being withdrawn. Senator Birdwell, Chair of Committee to which bill is being re-referred.
Any objection? Hearing none. Motion adopted. Members, the President's desk is clear. Senator Schwertner for announcement.
Thank you, Mr. President. Members, Senate Commerce on Business and Commerce will reconvene 15 minutes upon adjournment E1.012. Thank you, Mr. President.
Any other announcements? Senator Middleton.
Thank you, Mr. President. Members, as a reminder, the Senate Subcommittee on Higher Education will convene today upon adjournment at my desk to report bills without recommendation to the full Committee on Education.
Any other announcements? Senator Hinojosa.
Thank you, Mr. President. I just want to announce that the work group for finance on Article 1, 4, and 5 will be meeting 15 minutes upon adjournment.
Anyone else? The chair recognizes the Dean of the Senate for a highly privileged motion.
Thank you, Mr. President. Members, I move the Senate adjourn until 11 a.m. Wednesday, March 15th, and we do so in memory of James Flanagan, a constituent of Senator King. Thank you, Mr. President.
Thank you, Dean. Any objection? Hearing none. The Senate stands adjourned until 11 a.m. Wednesday, March 15th. Thank you, members.